Yes, Mr. Ramlogan, are you still hearing us?
I'm hearing you loud and clear, my lord.
And you're very clear.
Thank you. My lord, can I now turn to the Court of Appeal judgment to show the board how the Court of Appeal reasoned and treated with these matters? And I take you to page 311. At paragraph 24 on page 311, the Court of Appeal began its analysis. The documentary evidence to which reference is made above consists of correspondence passing between solicitors and conveyancers of the respondents in 1980 and 1981. It formed part of an agreed list of documents which were admitted into evidence, and there is therefore no dispute as to its authenticity. We've already been through the document, so I shan't repeat the parts of the judgment that simply recites the relevant passages from it. At paragraph 26 on page 312, the court says, it is reasonable to infer that the description of the land as contained in that letter is taken from the Gordon-Farrell plan as the description is the same as shown on the plan. It is also relevant to note that according to that letter, the second respondent is described as a prospective purchaser of 56.5 acres and no more, and that's what is shown in the Gordon-Farrell plan. According to the evidence of the respondents, the deceased had rejected that plan and requested a resurvey. This survey would have had the effect of redefining the eastern boundaries by moving that boundary eastward to meet the river, which is the eastern boundary of the estate, and so enlarging the area of the parcel of land to be sold to the second respondent. As he died in 1977, that would have occurred before 1980 being the year in which the letter is written. The letter, however, makes no mention of any notion of the resurvey of which the respondents testified. Instead, it adopts the description of the lands in the Farrell plan and describes the second respondent as the prospective purchaser as shown on that plan. The letter, therefore, simply does not support the respondent's case and is inconsistent with their cases. Paragraph 28, the evidence, second sentence, the evidence in this matter suggests that the second respondent was seeking financial assistance from the bank to purchase lands. It is reasonable to assume that the letter is written with a view to progressing the sale of the lands to the second respondent, comprising the 56.5 shown in the Gordon-Farrell plan. At paragraph 30 on page 313, just scrolling down, the deed of conveyance enclosed with the said letter is made between the respondent as executrix and as the vendor and the purchaser. The deed relates to the parcel of land described in the schedule to the deed. That parcel is 56 acres. The boundaries of the lands are described in the Gordon-Farrell plan. The deed makes reference to a plan as being annexed to the deed in which the subject parcel of land is delineated and colored pink. However, a copy of the plan is not annexed to the copy of the deed in the record of appeal. I don't believe, however, there's any dispute that given the acreage of the parcel of land and the description of the boundaries, that it's referring to the Gordon-Farrell plan. It's clear by this letter, therefore, the solicitors have prepared a deed of conveyance comprising 56.5 acres as per the Gordon-Farrell plan and sent it for approval and execution. This lends no support to and is indeed contradictory of the evidence of the second respondent that the Gordon-Farrell plan was not accepted by the first respondent and that he had to have the lands resurveyed and that the eastern boundaries of the land to be sold had to be redrawn and that the redrawn plan had to meet the approval of the first respondent and that the sale to him would be concluded only after that was done. I take you to paragraph 34 on page 315. The letters are remarkable having regard to the pleaded cases of the respondents and their evidence. There is no mention that the acreage of the parcel of land to be sold and hence the purchase price would be determined when the lands have been resurveyed and the boundaries redrawn. In fact, there is no objection to the description as it comprises 56.5 acres. The letter states that there was an agreement that they would purchase the land described in the deed forwarded by Polliner and Blah, and the parcel of land is 56.5 as shown in the Gordon-Farrell plan. The reasons for the delay in the completion of the sale, according to the letter, have nothing to do with a survey of the lands yet to be done. It is said to be due to the untimely death and the consequent probate proceedings. There is no indication that the deceased or the first respondent expressed any displeasure with or objection to the Farrell plan annexed to the deed of conveyance. There is simply no mention that they were directed to undertake a new survey of the lands to be sold, and there is no indication that the area of lands to be sold was to be enlarged, which would be inevitable if the eastern boundary was to be redrawn in the manner described by the respondents. Presumably, this right-of-way is over the existing road reserve and would fall within the boundaries of the 56.5 acre parcel. So insofar as the right-of-way issue cropped up, the Court of Appeal was of the view that that right-of-way would have had to been catered for within the 56.5 acre parcel. And that's why in paragraph 36, they say, about 8 lines down, the first is that as regards to the purchase price, the second respondent made it clear that the price that was agreed was $300 per acre, which translates into $16,950 for the purchase of the acreage. The second is that the Gordon-Farrell plan was required to be if the Gordon-Farrell plan was required to be redrawn to show the right-of-way, as the solicitors seem to think, this did not speak to a resurvey that required a redrawing of the eastern boundary and an enlargement of the parcel of land to be sold to the second respondent. There is nothing in the correspondence to support the respondent's case about them having to retake the survey.
But the actual issue between the parties was what had been agreed between the Gifts and Miss Latour in 1998, and their evidence was very clear that she had said, I've sold this land to Dr. Rowley, it's 56.5 acres plus or minus, and their evidence is she was very clear in their discussions in 1998 that that was what was going to be carved out, and her evidence was, no, in those discussions with the Gifts in 1998, I made it very clear that actually it wasn't set yet what Dr. Rowley's portion would be. That was still being agreed, right? Now, you've taken us to all that cross-examination about the correspondence, but there must have been a whole other pages of cross-examination about what was said between the Gifts and Miss Latour in 1998 for the judge to decide which of them was telling the truth as to what had been said at that stage. Now, I know you say that this correspondence doesn't mention the surveys, and that backs up the Gifts' claim that in 1998 she told them that it was set at 56.5. But that was the issue the judge had to decide, not what had happened in 1980 or 1991. Isn't that right?
Well, yes, but in deciding that issue, the judge had to weigh in the balance the two competing versions of what was being put before the court. Our client said that Miss Latour had never told him about any resurvey to be done, but that she was clear in terms to him that she had sold 56.5. Based on the Farrell plan, and he was consistent throughout that. So in evaluating the evidence of the respondent as against that of Ms. Latour and the appellant, she had a duty to weigh in the balance the impact of the contemporary evidence in a case that's, you're talking about memories, 35-year-old memories that would have obviously faded.
It's a memory of back to 1998 as what had happened then.
Sure, I accept that, but Melody, in the context of the correspondence being written at the time when litigation was not on the cards, what we say is that that ought to have been accorded, a high probative value over and above the oral recollection of the parties, so many years after the fact. It was the best evidence rule is what ought to have prevailed and been applied. And the best evidence rule in cases like this would be that there must be some primacy given to the correspondence that was contemporaneous and drafted at a time when there was no litigation on the cards, written by lawyers who were not called to defend themselves from the indirect serious accusation of professional misconduct, that they had written letters based on that were either contrary to instructions given or that were dreamt up by them as a figment of their own imagination. And it's a rather serious matter when you view it from that perspective. It is inherently incredible. So that whilst the judge did have to decide that, it was not something that she could divorce, as it were, from the jigsaw puzzle of the evidence that presented itself before the court. She had to take the evidence on the totality of all the evidence in its entirety and to properly analyze it. When one looks at the analysis in the judgment, this, which is the linchpin of the case, simply doesn't feature. So that it's a fundamentally flawed evidential analysis from any perspective, and that's why the Court of Appeal was justified in intervening. So that, the Court of Appeal, I mean, we couldn't get a better quote than the one from the board in Reed and Charles, which is at paragraph 38, where in Reed and Charles, the board said, Mr. James Guthrie, in his able submissions on behalf of Mr. Reed, emphasized to their lordships that where there's an acute conflict of evidence between neighbors, particularly in rights of way disputes, the impression which the evidence makes upon the trial judge is of the greatest importance. This is certainly true. However, in such a situation where the wrong impression can be gained by the most experienced of judges, if he relies solely on the demeanor of witnesses, it is important for him to check that impression against contemporary documents where they exist, against the pleaded case, and against the inherent probability or improbability of the rival contentions, in the light of the particular facts and matters which are common ground or unchallenged or disputed only as an afterthought or otherwise in a very unsatisfactory manner. Unless this approach is adopted, there's a real risk that the evidence will not be properly evaluated, and the trial judge will in the result have failed to take proper advantage of having seen and heard the witnesses. We say that the Court of Appeal was right to light upon this passage from the board in Reed and Charles, because that's precisely the error that the judge made in this matter, which she didn't check the impression she formed of the witnesses against the contemporary documents and the pleaded case to evaluate the inherent probability or improbability of the rival contentions. And that's where she went wrong. That's why in paragraph 39, the court said the correspondence to which reference was made was written 5 to 6 years after the agreement, at a time when litigation was not contemplated and at a time when matters were relatively fresh in the minds of the respondents. It was clearly material and important evidence. It was therefore important for the trial judge to consider this documentary evidence and take it into account in assessing the credibility of the evidence of the parties. This she did not do. This is patently clear. The only reference to the correspondence appears in paragraph 24 of her judgment, where she summarized the submissions of the appellants. She appears not to have appreciated the relevance and importance of the evidence. Now, I don't think it will be a good use of my time, because I have to cede to my learned junior, Mr. Goldblatt. But all I can say for the board is from paragraphs 309 to 330, Court of Appeal undertakes a very detailed analysis as to why it was so improbable to say the lawyers had gone off on a frolic of their own, and why failing memories after 35 years required a greater depth of analysis having regard to the contemporaneous documents. Why, for example, the Court of Appeal felt the idea that you couldn't find a surveyor for 35 years ought to be rejected. Why, for example, one suddenly appeared quite easily after the claim was filed, and so forth. So I will commend those paragraphs.
Can I just, Mr. Ramlow, can I just follow up
yes.
my Lady Rose's point? As I understand it, the crucial question is what the parties agreed in 1998. So what's being said between them is, on one version, we're selling you the land minus 56.5, and on the other version, it's we're selling you the land minus a larger amount covered by the subsequent survey. So that is, in essence, the question of fact that the judge has to decide. Now, it's quite clear that the evidence that she heard from Ms. Latour in relation to that was that at that time, her understanding was that the land that was being deleted, so to speak, was 56.5 plus what would turn up in the other survey, that is the larger amount. Now, the fact that 20 years prior to that, she may have had an incorrect recollection, is it not, of secondary importance?
Well, my lord, I say no, because insofar as the evidence boiled down to a contest between that of Latour's evidence and Gift's evidence, Ms. Latour's evidence was so discredited in cross-examination that it simply could not have been a reasonable finding supported by the evidence either taken as a whole or by reference to the contemporary document.
But clearly the judge believed that in 1998 she understood and made it sufficiently clear that it was the larger portion of land that was being kept for Dr. Rowley. She clearly took that to be the evidence because she believed, or I think we must assume believed, what Ms. Latour was saying. Now, you're putting against that, well, that goes contrary to the fact that Ms. Latour couldn't be a credible witness because back in 1975, she had agreed to something that the contemporaneous evidence showed to be inconsistent. But it might be said that that is really relatively peripheral if the judge is overall taking the view that this is an honest witness about what was happening in 1998.
Well, my lord, there are two things with that, my lord. The size of the larger portion, the extra bit that we're talking about, in the context of the exchange of correspondence with respect to the demand for interest and so forth. I mean, if we follow logically this evidence, you have an offer and an acceptance, and you have a conflict which arises where there's a counter offer and the introduction of a demand for interest, for example. If we accept their own evidence, if you rejected the Farrell plan and the 56.5, then at that stage there is no agreement, as it were. There's no consent. They're not consensus addendum on that. And what you have really, in effect, it seems to be maybe a counter offer with a demand for interest thereafter, and with a new agreement, perhaps, for this larger parcel to somehow be included. I mean, I get the impression, the impression really was that given the length of time that had lapsed, without any evidence as to what, if anything, took place, it really doesn't leave it open within the bandwidth of reasonable findings for a judge to make the finding that that was made in this matter, my lord. But can I say, my lord, I must pass the baton to Mr. Goldblatt, who will, of course, answer these questions during the course of his submissions to the board as well, with far greater clarity as well.
Well, thank you, Mr. Ramlogan. Unless anyone has any further questions of Mr. Ramlogan, I think we're invited to direct them at Mr. Goldblatt. So, Mr. Goldblatt.
Mr. Blige.
I think you've effectively got about 35 minutes, Mr. Gelblatt.
Thank you, my lord. I will keep an eye on the time. My lords, my lady, I hope to address some of the points that have been raised most recently by my Lady Rose and my Lord Burrows about the 1998. It's going to be the focus of my submissions and what was agreed in 1998 and the cases put by the parties. But I'm also going to deal with, so that falls under our additional grounds of appeal, really.
Can I just input one more question for you to deal with at a suitable time of your own choosing? I think my understanding was that that Ms. Latour's case about what was agreed in 1998 wasn't that there was definitely going to be more than 56 acres, but that it simply hadn't been decided what extent of land was going to go to Dr. Rowley. I may have misunderstood the evidence on that, and if I have, I'd like to be shown.
My lord, I'll take you to the pleadings.
Was agreed.
Yes, I'll take you to the pleadings. I think the primary submission on the 1998 point is that the judge failed properly to consider the meaning of the words in the receipt, and specifically the meaning of that there needed to be a survey, and whose survey it was that needed to be procured. And my submission is that the judge plainly got it wrong. She seems to have concluded that it was subject to Dr. Rowley obtaining a resurvey of the lands that he wished to acquire. However, the only reasonable conclusion was that the agreement to sell the remaining lands was actually subject to the gifts obtaining a satisfactory survey. Could I take you first to the receipt itself, which is at page 30 of the bundle? My learned friend, Mr. Maharaj, took you there and also noted that the wording is agreed in the SFI, at paragraph 16 of the SFI. So this is dated 9th of September 1998, and it says, deposit for remaining lands at Alma Estate, Tobago, standing in name of Frank Latour, deceased, executor Marcelle Latour, amount per acre 5,000 TT, to be ascertained after survey, total remaining balance of purchase price. Now, this is really the only contemporaneous document around 1998, and at the time of the agreement between the gifts and Miss Latour. And it's a memoranda of the agreement in our submission, and it sets out what, under where it says for, it sets out exactly what the gifts were paying their £30,000 deposit for. And I think, as my Lord Briggs noted, there isn't really a dispute before the board about the certainty of this being a contract for sale of land. There isn't really in dispute. The High Court's analysis of this can be seen starting at paragraph 47 of the High Court judgment, starting at page 170. Paragraph 47, where she says, there's no dispute among the parties that the claimant paid to the first defendant the sum of $30,000, receipt of which was evidenced by a written receipt issued by the first defendant to the claimants, on which was endorsed a statement that it was for the remaining lands of the estate of Tobago. And then at paragraph 48, she seems to be referring to what the condition is, which seems to be a reference to be ascertained after survey. And her analysis of what that means would be ascertained after a survey was done and after sale to the second defendant. And at 49, she poses the question that the Court of Appeal do much to deal with, where she asks why none of these parties has sought to finalise their respective deals with the first defendant to purchase a portion of the estate lands. She says they must be waiting for something. And that something was her conclusion is that something is a resurvey by the appellant, by Dr. Rowley. And we know she's talking about the receipt here as well, because paragraph 50, she says the court finds that the first claimant supports the court's view as revealed in cross-examination, finds that at all times from issue of the receipt to the claimants to the first defendant's visit on the estate lands in 2009 to date. Now, if I could take you to the amended particulars of claim. The original particulars of claim were dated January 2009. These amended ones are June 2009. So this is very shortly after the dispute actually arises between the parties, which is very early 2009, and around 10 years after the 1998 agreement. So just starting at paragraph 3.
Sorry, page.
Sorry, my lords, my lady, it's starting on page 16 of the bundle, paragraph 3.
Yep.
This is where the respondents set out their case as to what was agreed. Paragraph 3 sets out the deposit. And then paragraph 4, it said the defendant also communicated to the claimant her inability to say exactly how much land of the said parcel of land that was then left to be sold. Firstly, because of her concern over her deceased father, the said Frank Latour had sold portions of the said parcel of land prior to his death, not all of which was known to the defendant, and thereby necessitating a search of all available land documentation records. And then secondly, there's this point which arose over the issue of there being, it's said by the respondents, by the gifts, that they were told by Ms. Latour that she had not, in fact, sold the 56.5 acres to Dr. Rowley. And there may well need to be a slight adjustment to that southeast portion of the Farrell plan to take into account the need for a road reserve, because I think you can see from the maps we've shown that the road and the river come very close at that point in the southeast corner. In cross-examination, which I can take you to later, it was put to Mr. Rowley that actually there was a concluded agreement because there's this receipt from 1975, and he openly says in cross-examination, well, I only saw that receipt during disclosure. It's not what we were told by Mr. Latour at the time. And then what the gifts say was in agreement is at paragraph 6. So the claim...
Their case was that they were definitely told by Miss Latour that the amount she'd agreed to sell to Dr. Rowley was 56.5 acres.
Exactly, my lady.
Well, not just that, but that it was the 56.5 acres appearing on the plan marked B.
Yes, which is the Farrell
In other
plan.
words, as I read the pleading, they're saying, actually, what's that plan called? The Farrell plan was sort of on the table in front of them, and the oral agreement was about that, the land shown on that plan.
Yes,
but otherwise, it's not clear to me how the claimants could have known about the Farrell plan.
And in cross-examination, Ms. Latour says, I didn't give them a copy, but then she concedes, I may have shown them a copy of the Farrell plan.
Okay.
So yes, their case is essentially the Farrell plan represented the maximum amount that would be sold to Dr. Rowley, and she didn't know what else was in the estate, and we'd need to find out. And there may need to be an adjustment to Dr. Rowley's portion because of this issue of the access road on the southeast corner. And we have paragraph 6. They set out that agreement, the need for any adjustment, and then at paragraphs 8 and 9. They set out what they did to engage that agreement. They engaged us. They said they're willing to fulfill and perform their obligations under the agreement, and they in fact engaged a surveyor. So on the respondent's understanding, the surveyor referred to in the receipt is obviously a survey to be conducted by them, because they say they need to understand what lands are left in the estate because of the way Mr. Latour had sold them during his lifetime in a fairly ad hoc, haphazard way. And they also need to know about this issue in the southeast corner. And that's an issue for the benefit of them, to know that they have...
The survey for them is not only just that little border, it's where the land backs up against other people's.
Yes, it's to know how much land is left in the estate, exactly what the full
Yeah.
scope of the land is.
If you sell land subject to a formula price per acre, and you don't know what the acreage is, somebody's got to do a survey.
Yes, that's the mechanism for finding it. Exactly, my lord.
But is your point now that you think that the judge thought that the reference in the survey to the memo, was actually to the Dr. Rowley survey?
Well, in my submission, reading through the High Court, reading through the judge's judgment, where she says, she sets out essentially what's in the receipt and says they must be waiting for something.
When she refers to that bit, she always calls it a resurvey.
Yes.
Well, 48 of...
No, I'm just if that's what you're... I'm just wondering whether you're tilting it a bit of a windmill as far as...
Well, I'm not sure, my lady, because 48 she calls it after a survey was done. She doesn't call it a resurvey there.
No.
That's a primary conclusion.
No, but the inference she's drawing in 49 isn't an inference as what's meant by subject to survey in the receipt. It's an inference from why neither side, neither potential purchaser, got anywhere nearer completing a purchase during the next 10 years.
I get onto that, my lord, and actually the Court of Appeal deals with that specifically as to actually stuff was being done by the claimants in pursuant of that agreement that they obtained in the survey. So if I could then take you to actually what Ms. Latour says in her pleaded case, starting at page 40 of the bundle.
40?
40. And this is from the defence file 20th of July 2009. So really, again, not long after the dispute arises. This is while the dispute is still fresh in Ms. Latour's head. Well, albeit the 1998 agreement is 10 years previously, but the dispute is fresh in her head. Paragraph 14, starting page 40 of the bundle. And here she's addressing paragraphs 3 to 6 and 9 of the amended statement of case. The defendant was aware at all material times of what parcels of land had been sold from the Alma Estate from the records kept by the deceased, and the only parcel of land left to be sold across the river, but was able to say what was the area of land still available for sale. So she's saying that's rubbish when you plead that when you needed to do a survey to investigate what was left. I knew exactly what was left. It's in my records. Then going down at paragraph 15, she repeats again in that last line, the defendant was aware of those parcels which had been sold. And then paragraph 16, in yet further response to paragraphs 3 to 6 and 9 of the amended statement of case, the defendant denies that there was a potential purchaser at all material times the claimants were aware of the identity of Dr. Keith Rowley, and that he had agreed to purchase a parcel of land, and that it was awaiting resurvey. The defendant expressly admits that she informed the claimants that they could not buy until Dr. Rowley's boundaries had been properly established as set out above. There was a long delay on the part of Dr. Rowley having the land resurveyed, and the reason thereof the defendant was not in a position and did not agree to sell to the claimants any identified parcel of land and did not agree to any access. So this suggests that the survey is actually to be a resurvey by the appellant. And paragraph 18a, Ms. Latour expressly denies that a survey was to be by Mr. and Mrs. Gift. This is pleading to paragraphs 8 and 9, where the Mr. and Mrs. Gift had said we're willing and able to do all we can to further our part of the bargain, which is, obtain a surveyor. And she denies that to any retainer by the claimants for a proposed survey in respect of the Alma Estate, and was not asked for nor did not grant permission for such a survey to be carried out on behalf of the claimants. And again denies the need to ascertain title, be to ascertain by the claimants of the title surveys of the Alma Estate. And again she says at paragraph 19, at all material times any proposed sale to the claimants was conditional upon the reserve of the lands agreed to be sold to Dr. Rowley. So her case is carefully crafted to say, essentially, the after survey that you have in the receipt can't be your survey, because I didn't give you permission to have a survey. I didn't need a survey, because I knew everything that was in the estate. And so the resurvey must be a survey must be the resurvey by Dr. Rowley. That must be what I meant. So she locks in that position in her pleading. And then it all comes apart in cross-examination. Cross-examination starting on page 722 of the bundle. Starting at line 5, Ms. Latour is asked, so this is the receipt you gave to Mr. Gift, to the Gifts? And you said you make a reference to survey. That is a survey to determine the extent of the lands that remain. That was a survey for Mr. Gift, to whom? It would have been a survey. The survey that you refer here, Mr. Gift hadn't given me any survey yet. And then jump down. We haven't done any survey as far as I know. The survey that you referred, this is slightly evasive, the survey that you referred to after survey, that is the survey of the lands that would be remaining to know the purchase price. Well, of course. And as you said earlier, it was the purchaser's responsibility to do the survey. That's referring to earlier where it was put to Ms. Latour that Mr. Rowley, as the purchaser in 1975, would have needed to obtain a survey as the purchaser. And she'd agreed with that.
I'm so sorry, I've got the wrong page number. Can you?
Sorry, 722.
Thank you.
Of course, and as you said earlier, it was the purchaser's responsibility to do the survey. After I had arranged selling the last portion. But as a general proposition, when I say that the last, it's, you suggest that it was always for the purchase of the lands to do the survey. Well, of course, so it had to. You have to do a survey to purchase lands. All right, so when you referred to the survey here, you're referring to the survey that had to be done by the Gifts. No, I didn't mean that survey. How would he know the purchase price? How would you know how much land it is? I had known because you had to do a survey. And who had to do the survey? Who had to do the survey? Mr. and Mrs. Gift. Now, it was never your responsibility to do any survey as far as you're concerned. That's right. And then, jumping back a bit at...
She's agreeing with you that the survey is...
Yes, she's disclaiming her position in her pleaded case. Her pleaded case was, I didn't give them permission to do a survey. I didn't give the permission for the Gifts to do a survey. There was no need. And just going to page 681.
681.
Yeah. So this is...
But this isn't denying that Dr. Rowley may have to do a survey.
No, it's not denying Dr. Rowley. This is Ms. Latour conceding that the Gifts would need to do a survey under their agreement.
Well, somebody would have to do a survey to work out how many 5,000 lots of dollars they had to spend.
Agreed. But it seemed to be...
that we see then at... the
1026, I think it is, yes. My lady, yes. But Ms. Latour's position in her pleaded case was that there's no survey needed to be done by the claimants.
Well, so you read this as being inconsistent with how you read the amended particulars of claim, in which you think she's asserting...
No, her defence, my lady.
Sorry, in her defence, you think she's asserting that the survey referred to in the memo is the Rowley survey, and she's saying no. In her cross-examination, she's agreeing that survey, whether it's done by her or by the Gifts, is the survey that's needed to ascertain the size of the remaining land.
Yes, in her defence, she says, I don't need to know by survey the remaining size because I have that in my records. Where you say you need... Mr. Latour sold...
That's dealing with the earlier bit about what other parcels of land have all been sold.
That is the remaining amount. My lady, the evidence was that you had the Alma Estate.
But there was somebody who beavered away in the records office, wasn't there, to work out...
Yes, the claimant surveyor.
The claimant surveyor?
Yes. Yeah.
So they needed to work out... So in the cadastral map that we see, there's all the names Samuel Thompson.
Yes, but Miss Latour was saying they didn't. In her defence, she was saying they did not need to do that because she knew at the time what was in the records. From her, she knew what had been sold. So just going back to Ms. Latour's defence.
Well, carry on, Mr. Gelblatt. I mean, thus far you pointed to evidence which appears to depart from their pleaded defence in one particular respect.
In one respect. And then, so that is in respect of them not needing to do a survey.
Yep.
And then just to make good the point that actually she also had no idea how much was in the estate, contrary to what's in her pleadings. This is on page 681, starting line 20. It is in the statement, now, during your father's lifetime, he sold several portions of land out of the Alma Estate. Yes, he did. And his modus of selling these lands would be to issue receipts to the people who are interested. Well, not exactly. He would have to go to the place where in those days there weren't a lot of surveys about, so he would go and they would discuss what piece of land. I'm going back to the 30s. I could imagine, yes. So they would discuss what they had when they put boundary plants. You remember boundary plants, so on and so forth. And so they arrive at a price. They did not register them right away. It was years later. And after your father would not have drawn up formal agreements of sale with these people that he was selling lands to. Well, some who could afford it, but a lot of them were not able to afford. And he would simply issue receipts to them what they'd paid him. Well, of course, because they would pay maybe $50, whatever they could afford. Now, because of that, at the time of your father's death, you would not have been able to say how much lands in the Alma Estate were left. That I had no idea. You had no idea. So again, entirely contrary to what's in her pleaded case, that she knew because she had the records, but actually she had no idea.
So these points you're making, they were all made to the Court of Appeal, were they?
So they're made to the Court of Appeal to the extent that I can take you to page 219 of the bundle, paragraph 76.
But all this is... Sorry, go on.
No, I mean,
I'll leave you with that.
Is that the judge, as to the crunch of the pleaded case and the crunch of the evidence, what was said between the gifts and Miss Latour, the judge preferred Miss Latour's evidence, and all these points you're making, of which the biggest is the the letters, are all points you say should have caused her to prefer their evidence as to what was said in those discussions in 1998.
That her evidence is entirely inconsistent with her pleaded case as to who needs to produce a survey. It's obviously a survey by the gifts, contrary to what she was saying.
so you say these points were made to the Court of Appeal, but they don't appear to place any weight on them when you say they should.
Well, in the Court of Appeal, they go for a different analysis, which is at paragraph 50 to 52, where they take on the question of that the High Court judge poses of why has everyone been waiting so long? Why has no one done anything? And the Court of Appeal responds, well, actually, if you look at what the gifts have been doing, they've been progressing their surveys. They've had Mr. Fortune beavering away in the records and producing his plan, which he does in 2006/2007, and then they organise this 2008 meeting. So it's wrong to say that they haven't been progressing. We know from the evidence that it's difficult to ascertain what lands are in the estate, contrary to what Ms. Latour was saying.
So he produces a report 8 years later, is that right?
Indeed, but the evidence was it was difficult because of this haphazard way that Mr. Latour had sold his land to ascertain exactly what parcels had been sold.
You wouldn't spend 8 years of your professional life working on that.
My lord, I wouldn't know.
I mean, it hardly explains the delay any more than the extraordinary delay of 19-odd years after the original agreement with Dr. Rowley.
Well, my lord, I'd say there's a difference
Short
between...
a period of unexplained delay, but it's still, to any ordinary mind, an extraordinarily long period after a sale's been agreed.
Well, the evidence was that Mr. Fortune was engaged in 1998, which is very different to the position of Dr. Rowley.
Yeah.
And his position was he only produced his report in 2006-07. So the delay is not on the part of the gifts, at the very least. The delay would be on the part of the surveyor.
Might if I hadn't done anything for about 6 years after I engaged him, I think I would be banging on his door.
We
Anyway,
have high
so you're
standards.
But I'm not in
pointing
Trinidad or
out
Tobago.
You're pointing out various ways in which her evidence conflicted with what she'd put in her defence.
Yes. My Lady Rose, you pointed out that the question is of memory from 1998, and that's really a question for the judge, but it was more than 10 years. What happened? These pleadings were it was more than 10 years after the dispute arose, and 18 years before the evidence was actually given in 2016.
So that goes for the gifts as well, doesn't it?
Yes, but what we did have was the 1998 receipt, what it said, and we had those earlier contemporaneous evidence. And there's no attempt by the judge to do.
It doesn't help very much, does it?
Well,
Except to say that there has still got to be a survey.
and in my submission, it has to be by the gifts.
See that?
But what the receipt doesn't say is the remaining lands after deducting 56.5 acres for Dr. Rowley.
It doesn't. But it is a memorandum. Unlike, I think, under the 1989 Act here, it has to contain all the terms. It doesn't under Section 41. And so here the judge doesn't check her impressions against the pleaded case, which was the point raised in.
But that's really a point for cross-examination, isn't it? I mean, you put it, don't you, to the witness? Well, your defence said this, now you're saying that. I mean, I don't know. Here we are. It's a sort of, it's not a very big point to take on a second appeal, may I put it that way.
My lord, it is the point being taken.
It goes into cross-examination. It therefore goes into the assessment in the first place by the judge of the witness's evidence.
Yes, I think a similar point was put by my Lord Burrows about the issue of cross-examination and whether it was put squarely to Miss Latour that her father had never required a resurvey. And I think as Mr. Logan took you through the cross-examination, the correspondence was put squarely to Miss Latour. And as you could see from the correspondence, well, that question wasn't put directly, has to be accepted. Her account is clearly challenged. And it's clear from the tenor of the cross-examination that doubt is cast on Miss Latour's case. And taken together, it made Miss Latour's case improbable. And so the judge isn't bound, just because it isn't put to her in cross-examination, the judge isn't bound to accept her case where it is improbable. In terms of the importance of documentary evidence.
So what you're saying about that is, which bit are you saying is improbable? Were you isolating part of the case, or were you...
Mr. Logan was dealing with was her assertion that there needed to be a resurvey.
Or that her father had required it.
That her father had required, and I'm applying
Yeah.
similar test to 1998.
But, I mean, the thing you have to jump over then is why, when she could have got for those 29 disputed acres, if she could have sold them to the gifts for $5,000 an acre, why she was insisting that she wanted to sell them for $300 to Dr. Rowley, if she hadn't at the time in 1998 got into her head that that's what her father would have wanted.
Well, that was a similar point put by my Lord Burrows, that her father would have wanted to sell to Dr. Rowley. That wasn't her case. Her case wasn't that her father adored Dr. Rowley and wanted to sell this land to him. Her case was that he had specific topographical requirements for any sale of that land.
Yeah, all right. I meant that why would she prefer to sell a larger amount than she had to if there had actually been no objection from her father as to selling the Farrell plan slice?
My lady, that question of motive of not selling really, in my submission, doesn't flesh out on either side within the case. Other than the point about that topographical requirement over.
Well, I don't know. If I was the judge presiding over this, I would say to myself, as Judge Kangaloo may have said, it's very strange that Miss Latour is siding in this litigation with Dr. Rowley, who's only offering her $300 an acre, when it would be in her interest, the interest of the estate, to say, actually, Dr. Rowley, you're stuck with 56.5 and I'm selling the 29 acres to the gifts for $5,000 an acre. Isn't that a factor that she may well have weighed in deciding what actually happened in 1998?
My lady, it might well be, but I mean, there's a dog that hasn't barked in this that I don't really want to raise, which is Dr. Rowley's own position. Just the other, my lords, my lady, are there any other questions on that specific point about the 1998 agreement? I think I've answered questions on that. The other additional ground was the judge effectively terminating the 1998 agreement. Here,
What's your position on this?
That she wasn't entitled to do it.
Right. So if the agreement is as she found it, you want to go ahead with the agreement to purchase?
Judge, my lord, I don't have instructions on that, but it's not for the judge to terminate the agreement. The agreement would still stand.
I mean, your real point is that neither side pleaded that the agreement had gone off.
No.
So the judge went an extra step in giving you back your $30,000.
Yeah.
Whereas you might want to go forward even if Dr. Rowley gets the 85.6 acres.
We may wish for that slice that you see at page 1025. I can provide authorities if required by the board about judges overstepping pleaded cases and what's required, what the parties have actually asked for. An example is the case of Citation Enterprises Limited and Burton. We're happy to provide those if necessary, but I think the board can take it as read that judges really permitted to.
That sounds right. What was the name of the authority again, Jessica?
Satcham Enterprises
Just spell
Limited.
that? Sorry.
SATYAM.
Yes. Enterprises
Limited and Burton.
And Burton.
2021 EWCA CIV 287. It's about judges stepping beyond the pleaded
Yes.
But as a general proposition, my submission is judge should not effectively break contracts on behalf of parties.
Was she addressed on that at all?
No, she wasn't. She didn't invite. She didn't invite submissions. It's dealt with in the Court of Appeal.
I think both. I think the majority and minority are agreed on this point.
Yes, they are.
So what do you say about the order that Judge Lucky would have made?
Which is,
Page 343.
disposition.
My lord, I don't have instructions on that as it were, agreed alternative order. But just to give you the references for where it was discussed in the Court of Appeal, page 853, paragraphs lines 29 to 50, and then 1 to 8 on the next page. And then you have in Ms. Latour's own witness statement her preparedness to sell the remaining lands to the respondents. This is at page 960, paragraph 31. Lord, my ladies, I realise I don't have very much time at all. You have our written submissions on the other points raised by the appellant. That's at paragraphs 28 to 35 of the respondent's case, and also dealing with one of those is dealing with there being no requirement for a finding of dishonesty on the part of Ms. Latour. Dr. Rowley would say that wasn't necessary. My Lady Rose asked about the evidence of topography. and specifically, what does it mean to say that it's not convenient because of topography of land? Mr. Strang provided some citations in cross-examination. In my submission, these only went as far as asking the witnesses, did a specific boundary cross a given contour line? There wasn't evidence actually about the importance of topography.
The judge, I think, referred to some expert evidence
Yes.
on this, but you're saying there wasn't any.
No, there wasn't actually expert evidence on the utility of, on the importance of topography. All that was put to these experts was, did this line did this boundary cross this contour line, yes or no?
Yes, I see.
That's not an explanation for it was topographically important.
But do the expert evidence to which the judge referred on this point, is that in our bundle?
It is in your bundle, yes.
And I rather assumed that one of the references that Mr. Strang had given us was to that, but maybe not.
Yes, my submission is that those references just go to the cross-examination of did a boundary line cross a contour line rather than a question of what is the impact of that. And your question to the other side was, what does it mean to say it is not convenient because of the topography of the land? And there wasn't evidence on convenience of the topography, which your question was directed at. Finally, just very, very briefly want to address my Lord Borough's point about the I think I've already addressed you actually about the point where you said that there's a difference between Ms. Latour saying she felt duty-bound to sell to Dr. Rowley, and we say that wasn't her case. Her case was she wished to sell to Dr. Rowley. That her father's wishes were to sell not to sell to Dr. Rowley, but he would not sell to him until a resurvey had been done and was conditional on the sale to the gifts. And the evidence we submit shows that was improbable, and the judge was plainly wrong to conclude as such. My lords, my lady, if there's anything else I can assist with.
No, thank you very much, Mr. Gilbert.
Thank you.
Mr. Melvin, Roger. Yes, Mr. Strang.
Yes, my lord, my lady. Perhaps I'll just turn to the last 2 points raised by my learned friend, Mr. Goldblatt. With respect to the argument that the judge was wrong to order the return of the deposit, understanding this to be an argument that if the judge was right not to order Miss Latour to sell the disputed 29.1 acres, there was nevertheless an enforceable agreement in respect of the rest of the remaining land. The position of the appellant is that's not a point made against him, and it's not one on which he has a strong position either way, because it's an order that the respondents are asking the court to make against Miss Latour, who's not a party to this appeal. Really, perhaps, it ought to have been made by way of a cross-appeal in respect of which Ms. Latour should have been a party. And I don't really have much more to say about it, other than that. But if I was to say something in support of the judge's position, it would perhaps be that if she did find the agreement to be unenforceable, it would be open to her to order the return of the deposit. And that might well be how the judge ended up when one considers how the claimants put their case, which...
well, she rejected the claimant's case.
Yes, exactly.
The question is, what agreement did she think had been made and whether that was enforceable?
Yes. The way the claimants put their case as to whether they had an enforceable agreement at all, if you like, depended on establishing the proposition that the 56.5 acres to be sold to Dr. Rowley was fixed. it was that which they said made their agreement enforceable. So if she finds against them on the first proposition, it may follow that she's going to find against them on the enforceability question. But as I said, it's not a
It
position.
actually doesn't arise, does it? Because that order has been set aside and the person who would appeal against the setting aside isn't a party to this appeal. That's the point
Yes.
you've been making?
Yes.
Yes, I see that.
So, but that may explain the judge's...
So the deposit is still sitting with the estate, is it?
There may have been a stay, actually,
Yes, I don't know.
on the handing over
Well,
of the...
I don't think we're concerned with it.
Turning to the penultimate point made by Mr. Goblet, that the judge was wrong in her construction of the words to be ascertained after survey. First of all, there's one point I'd like to make about the defendant's plea. Just to, perhaps it's a correction or perhaps it's a misunderstanding on my part over the pleadings, but my learned friend took me to page 40 in paragraph 14. Where Ms. Latour had pleaded that she knew which parcels had been sold by her father. It's in the middle of paragraph 14, where so she says she knew which parcels had been sold, but was able to say what was the area of the land. I must say, I had always read that as a typo, and meaning to say, but was unable to say the area. So she knew the number of parcels, but was unable to say the area. So I certainly didn't understand that to be...
Well, you've got the but in your favour, haven't you?
Yes. But in any event, the real question is, did the judge make a mistake about what she was construing in the memo, in the receipt? And that's page 170. And the phrase that the judge is construing is expressly recorded by her at paragraph 47. A statement that it was for the remaining lands
Yes.
of the estate. And in paragraph 48, she says what she finds this condition to mean. She must be referring back to the condition, the remaining lands. She's not construing the words ascertained after survey. It's not her decision. Her decision is as to what the remaining lands means. And that's the short answer to that. Now, briefly touch on a couple of points made by my learned friend, Mr. Ramlogan. And he made the submission that memories fade, and so contemporaneous documentary evidence has to be contended with. And of course, that's right. But the correspondence in 1980 and 1981 is not contemporaneous with the discussions in 1975 and 1976, and it's not contemporaneous with those in 1998. And as my learned friend, my learned senior said, Miss Latour was not challenged on her evidence that her father, in 1976, rejected the Farrell Plan and asked for it to be redrawn. And the board has seen the lengthy cross-examination on the correspondence, and it's certainly true that Miss Latour's evidence as to her instructions in respect of the correspondence was challenged, but it was not put to her that the correspondence showed that her father did not object in 1976, 5 years earlier, 4 years earlier. One thing that didn't come out in the survey of the cross-examination of Dr. Rowley was that Miss Latour's evidence about her father's objections in 1976 was put to Dr. Rowley as true. page 760.
Page?
Page 760, line 23. Question, line 23. So the trial judge, we say, was entitled to accept Miss Latour's evidence about 1976. She was entitled to find that her father's objections in 1976 were not an invention by Ms. Latour. Of course, we can see what the correspondence in 1980 and 1981 says. We know the strong points that can be made from it. Dr. Rowley accepted that he was trying to move forward on the original plan, despite what he said was the Latour's earlier objection. By the way, a couple more references to where Dr. Rowley explained his case that were missed in my learned friend's survey. Page 762, line 26. Perhaps you don't need to go there, my ladies. 762, line 26, over the page, line 4, and 763, line 15. But the critical point, I say, is that whatever the instructions that were given to the attorneys in 1980 and 1981, whatever the reasons why the transaction didn't proceed at that time, allowing for fading memories about that, if the judge was entitled to find that the father's objections in 1976 were real, she was also entitled to find that Miss Latour was holding on to those objections in 1998, when she articulated her position to the gifts. And that was, as your lordships and your ladyship have put to my learned friends, that was the question in the case. How did she articulate her position to the gifts in 1998? My learned friend, Mr. Ram Logan, submitted that it follows from the 1980 and 1981 correspondence that Dr. Rowley and Miss Latour's cases were a fabrication. Well, that wasn't put to them at trial. It's not a finding I submit would be open to a court of appeal on appeal. And it's worth remembering that the claimant's case, as my learned senior said, the focus in their argument was to establish a specific proposition that Dr. Rowley had a binding agreement. And that was proven by events of 1980 and 1981, the correspondence. That was the focus of their case. You can see that as they open their written submissions at paragraph 26, which is page 71, and paragraph 26, page 71, and as they conclude their submissions on the correspondence and the probabilities, which is at page 77, paragraph 56.
Sorry, just give me that page again.
Page 77, paragraph 56.
Thank you.
So they were going at it from a different angle, if you like. They weren't challenging Ms. Latour's evidence about 1976. They were saying later events show that Dr. Rowley had a binding agreement in any event. And that...
Just for the 56.
For the 56 and a half acres.
So, and this is paragraph again, sorry.
56.
56. Sorry, thanks.
That, in my submission, explains the judge's frustration when she, in her judgment, expresses frustration that the claimant's submissions were blinkered as to the fact of the objection in 1976. But these matters are surely relevant to the judge's task as to credibility and in respect of what evidence the judge had to assess the credibility of Ms. Latour and Dr. Rowley, and to the materiality of the correspondence. And in my submission, that's a point not understood by the Court of Appeal. As we could see from the passage that you were shown by Mr. Ramlogan, page 313, paragraph 30. So, and it's towards the bottom, it's 5 lines from the bottom. This lends no support to, and is indeed contradictory of, the evidence of the second respondent, that the plan was not accepted by the first respondent. Now, the Court of Appeal there do not appear to understand that the evidence about the objections in 1976 was unchallenged. Just a couple of two or three minor points to finish off with, my lord. Mr. Ramlogan made the point that Dr. Rowley's 2 surveys were not done until after the claim was issued. Well, we need to be a little bit more careful about that. The Isaac survey was carried out in late 2008. And the plan was shown to the gifts before issued, the Isaac plan. And that's an agreed fact in the Statement of Facts and Issues at page 1245. Subparagraph B. My Lady Rose asked the question whether Miss Latour, what evidence there was, I think, whether Miss Latour was indeed sticking to the $300 in an agreement with Dr. Rowley. We can see that in the agreement that she executed in 2009 in his favour, which is at page 1028. And that's the start of the agreement. 1030 shows her signing this deed, shows her executing this deed, and one can see the acreage there, 85.62. And 1029 shows the consideration, $25,685. So that is 85.62 times 300. Finally, one more clarification. Mr. Ramlogan said that after his oral agreement with the Latours, Dr. Rowley occupied the 56.5 acres depicted in the Farrell plan. Now, I'm not sure if he was intending to say that Dr. Rowley occupied all the 56.5 up to the boundaries, but if so, that's incorrect.
I think he was just saying he hadn't strayed into the extra 29 acres. That's what I understood. He's nodding.
Yeah.
Thank you. Thanks for the clarification. That's all I had to add.
Well, thank you very much, Mr. Strang. And the board is grateful to all counsel, leading, rather senior and junior, both for their oral submissions and for all the hard work that has no doubt gone into the preparation of their written submissions as well. I can see your hand is up, Mr. Ramlogan.
My Lord, I'm grateful. I just wanted to clarify something. My learned friend did refer to me using the word fabrication, and I thought I meant to withdraw that and say I subsequently put it down to a fading memory. So I just wanted to put that on the record.
We understood that. Thank you, Mr. Ramlogan.
Deeply obliged. Thank you.
And I think all I now need to say is that the board will take time to consider their judgment on this unusual case.